I pulled up to the park because my son had texted me 3 words. I need help. That was it. No explanation. No call first. Just those 3 words at 6:47 on a Tuesday evening, and I knew. I don't know how I knew, but I did. I grabbed my keys off the counter and I did not even turn off the stove. He was sitting on a bench near the fountain, the one my grandchildren always want to throw pennies into. My son is 34 years old. He is broad-shouldered and 6'1", and he has never in his adult life looked small to me. But that evening he looked small. He had a duffel bag at his feet and a backpack slumped against the bench leg, and my 4-year-old granddaughter Wren was asleep across his lap with her little sneakers still on, one of them half untied. I sat down next to him. He said, "She changed the alarm code and had the locks rekeyed. I came home from work and my key didn't work. My stuff was in the driveway in bags." I looked at Wren. I looked at the 2 bags. I said, "Okay." He said, "Mum, I don't know what I'm going to do. I don't have anywhere." I said, "You have somewhere. You're coming home with me." I reached over and picked up the backpack. "Can she sleep through being moved?" He said yes. I said, "Good." I carried the bags to my car, and he carried Wren, and we left. I did not let myself feel it until I was back in my kitchen at 9 o'clock that night, after Wren was in the guest bed and my son was in the shower and the house was quiet. I stood at the sink and I held the edge of the counter and I breathed. That is all I did. I breathed for about 90 seconds. Then I dried my hands and put the kettle on. I want to explain something before I go further. My name is Nora. I am 62 years old. For 31 years I worked as a certified public accountant. The last 18 of those as a partner at a mid-size firm in Columbus, Ohio. I retired 14 months ago. I say this not to make myself sound impressive. I say it because it matters for what comes next. Numbers are my language. Paper trails are something I understand very well. And I had been watching my daughter-in-law's father operate for 3 years with the particular unease of someone who recognizes a pattern but cannot yet name it. Now I could name it. My son's name is Evan. He married his wife. I'll call her by her first initial, T. 4 years ago, I am going to be honest with you, I liked T in the beginning. She was sharp and funny, and she made my son laugh in a way I hadn't seen since he was a teenager. I had real hope for them. The trouble was not T. The trouble was not T. The trouble, it became clear to me within the first year, was T's father. I will call him by what he called himself to everyone who would listen, a self-made man. His name was Roland. He owned a chain of auto parts stores across central Ohio, 14 locations, built from one store his father had actually started, though Roland did not mention that part often. He had money, not generational wealth, not old money quiet, but loud, new money, the kind that comes with opinions about how everyone else should live. He paid for Evan and T's wedding. He put the down payment on their house. He co-signed the mortgage because Evan was 2 years out of grad school and his credit profile was thin. At the time, my son came to me and asked what I thought, and I told him the truth. I said accepting that kind of money from a parent creates a debt that is not always financial. He heard me. He appreciated what I said. He did it anyway, because T wanted the house, and he wanted T to have what she wanted. I understood that. I did not stop loving my son for it. What I did do was pay attention. For 3 years I watched Roland insert himself into decisions that were not his. He had opinions about where Evan should work, and he expressed them at family dinners loud enough for everyone to hear. He had opinions about what neighborhood they should look at when T mentioned they might want more space, When Wren was born, he showed up at the hospital with a monogrammed blanket that said her full name, a name they had not announced yet, because T had told him in advance and did not think to tell Evan she'd done that. My son found out his daughter's name from a blanket his father-in-law was holding. He did not make a scene about it. That was Evan's way. He was a keeper of peace. He had learned that somewhere, and I had my own feelings about where, but that is a different story. The marriage had been struggling for about 8 months before the night at the park. Not dramatically, not loudly. They were not throwing things or screaming. It was the quieter kind of falling apart, the kind where two people start to feel like strangers who share a utility bill. T had started spending more time at her parents' house. Roland had started calling Evan less, which was actually a relief, until Evan told me what Roland had said to T, which was that she deserved better, and that the house was really her house anyway, wasn't it, given who had paid for it? The house was in both their names. I had checked this early on. I had asked Evan casually over lunch about a year after they moved in, and he had confirmed both names were on the deed. That mattered. But Roland was the kind of man who believed that legal facts were suggestions when he had enough money and enough certainty. The evening after I brought Evan and Wren home, I sat down with my son at my kitchen table. Wren was still asleep. It was close to 10, and the neighborhood was quiet. I made him eat something first. He hadn't eaten since noon. And then I asked him to tell me everything from the beginning and to not leave anything out. He talked for almost an hour. Some of what he told me I already suspected. Some of it was new. The part that made me set down my mug and sit very still was this. 2 months earlier, Roland had come to Evan privately and offered to buy out Evan's half of the house. He had presented it as a favor. He said T was unhappy, that the marriage was clearly not working, that the cleanest thing would be for Evan to take a fair price and walk away with no hard feelings. He named a number. The number was $80,000 below the current market value of the home. Evan had said no. Roland had not taken that well. I asked my son if this conversation had been in writing anywhere, a text, an email, anything. Evan pulled out his phone and scrolled for a moment and then handed it to me. There it was, a text thread between Evan and Roland initiated by Roland, in which Roland outlined the offer, and Evan declined, and Roland responded with 3 words, "You'll regret this." I looked at that text for a long time. I asked Evan if he had a real estate attorney. He did not. I asked if T had filed anything, separation paperwork, anything formal. He said not that he knew of. I asked him who had arranged for the locks to be rekeyed. He said T had told him it was Roland who called the locksmith. T had not been home when it happened. She was at her parents' house. Roland had used his own key, the spare they had given him 2 years ago for emergencies, to let the locksmith in. I said, "She gave her father a key to your house." Evan nodded. I said, "And he used that key to change your locks while you were at work?" He nodded again. I said, "That's illegal, Evan." He looked up at me. I said, "In Ohio, even in a separation, you cannot lock a co-owner off their own property. That is an unlawful lockout. It doesn't matter who paid the down payment. It doesn't matter who paid the down payment. It doesn't matter whose father called the locksmith. Both your names are on that deed, which means that house is as legally yours as it is hers. And what Roland did today, entering the property with a spare key to arrange a lockout of a legal co-owner, that is not a grey area." Evan was quiet for a moment. He said, "I didn't know I could do anything about it." I said, "I know you didn't." I did not say it with any judgment. I meant it plainly. He had not known because no one had ever told him, and Roland had counted on exactly that. I want to be careful here, because some of what I did in the following weeks I cannot walk you through in specific legal detail. I am an accountant, not an attorney, and for the actual legal steps we retained a real estate and family law attorney, Kevin, who came recommended by a colleague of mine. What I can tell you is what I did in the first 48 hours, which did not require an attorney, and which I believe anyone in this situation should know. The first thing I did the next morning, while Evan was getting Wren breakfast, was pull up the Franklin County Auditor's website and print a copy of the property record for my son's house. Both names, right there in black and white. I also printed the current assessed value. Then I looked up Ohio Revised Code 5321, which covers landlord, tenant, and occupancy law, and I found the relevant section on unlawful lockouts. I screenshotted what I needed, then I typed up a one-page summary of the facts as Evan had told them to me, with dates and times and a note about the text thread with Roland, and I saved it. This is what I mean when I say paper matters. You do not go into a situation like this with feelings. You go in with documentation. The second thing I did was call Roland. I want to be precise about this because I have thought about it a lot since, and I stand by the decision. I did not call him to threaten him. I did not call him with anger because anger is a luxury I have not been able to afford in situations like this, and I have had a few in 62 years. I called him because I wanted to give him the opportunity to do the right thing before I involved anyone else. He answered on the second ring, which told me he was not surprised to hear from me. I said, "Roland, this is Nora. I want to have a straightforward conversation with you." He said, very smoothly, that he was happy to talk, but that this was really between Evan and T. I said, "I agree that the marriage is between Evan and T. The property is a separate matter. Evan's name is on that deed, which means that house is legally his residence. And what happened yesterday, the lockout, is actionable in Ohio. I'm calling to let you know that we are aware of that, and I'm hoping we can resolve this without going that route." There was a pause. He said, "Nora, I don't think you understand the full picture." I said, "I might not, but I understand the deed. I also have the text you sent my son 2 months ago, the one that ends with 'You'll regret this.' I'm sure you remember it." Another pause. Longer this time. He said Evan had not been a good husband. He said Evan had not been a good husband. He said T was not safe. He said some other things that I let him say because when someone starts making claims like that on a phone call, I want them to finish, so I know exactly what I'm dealing with. When he stopped talking, I said, "If there are safety concerns, those are serious and they go through the proper channels. An attorney, a court, documentation, not a locksmith with a spare key on a Tuesday afternoon. I'm asking you to have the locks restored to what they were and to let Evan return to the property he co-owns by tomorrow morning. If that doesn't happen, we'll be filing for unlawful lockout, and I'll also be forwarding that text thread to Kevin." I used our attorney's name deliberately, along with the lowball buyout offer from 2 months ago, which speaks to intent. He said, "You hired a lawyer already?" I said, "I know a lot of people, Roland. I've been working in this city for 30 years. I let that sit." He said he needed to talk to T. I said, "Of course. I hope you'll call me back by end of business today." I hung up. Evan was standing in the kitchen doorway. Wren was behind him, holding a piece of toast, looking at me with the very serious expression she gets when she senses that adults are doing something important. Evan said, "What did he say?" I said, "He's going to think about it. Let's get Wren dressed." Roland did not call me back by end of business. He called back at 9:15 that evening. T was on the line too. There was some back and forth, some defensiveness, some deflection. At one point Roland said he had simply been looking out for his daughter, and I said that I understood that impulse completely, and that I was doing the same thing, and that perhaps we could both agree that our children deserved a resolution that didn't involve criminal exposure for anyone. That word, criminal, landed the way I meant it to. By the next morning, a locksmith authorized by T had restored the original locks. Evan had a new key. He did not move back in immediately. There were still things to work through, and my son and daughter-in-law had real decisions to make about their marriage. But he had access to his own home. He had his rights back. That was what mattered in that moment. The larger situation took several months to move through. I am not going to tell you that Evan and T's marriage was saved, because it was not. They separated formally about 6 weeks after that night, and they are now in mediation. It is not easy. It is not the outcome I would have chosen, but I will tell you what did happen. The buyout offer Roland had made was formally withdrawn once Kevin got involved, and made clear that any property settlement would be based on current market appraisal, not Roland's preferred number. Evan walked away from that house with his fair share, which was not $80,000 below market value. He has an apartment now, 10 minutes from my house. Wren splits her time, and she is doing okay. She still throws pennies in the fountain when we pass it. I want to say something to anyone watching this who is in the early hours of a situation like this. That moment right after the lock doesn't work and you're standing on the porch of your own house with your belongings in garbage bags, you need to know 2 things immediately. First, if your name is on the deed, that is your home. Period. Ohio, and most states, has clear law on this. A lockout of a co-owner is not a grey area. Document everything. Take photographs of the locks, of your belongings if they've been removed, of anything left in the driveway. Note the time and date. Get that down in writing for yourself within the first hour if you can. Second, find the paper trail, texts, emails, voicemails, bank transfers, anything where the other party stated an intent or made an offer or said something that reveals what they were trying to do. In situations like my son's, the text from Roland saying you'll regret this was not just an angry message. In context, it was evidence of a pattern. Courts care about patterns. You do not have to have a parent who spent 30 years in accounting. You do not have to know the right people. But you do have to know that you have rights, and you have to be willing to say so out loud. That is what I told Evan on the drive home from the park that night, not in so many words. But when he said he didn't know where he would go, I said, yes, you do, and I meant it in every sense of the phrase. You have somewhere to go. You have rights you can claim. You have options that no one can lock you out of. Wren woke up about halfway through that drive home and asked where we were going, and my son said Grandma's house. She thought about that for a second. Then she said okay and put her head back against the car seat, and that was that. Some nights it really is that simple. You just have to know whose door to knock on. If there's something specific you want to know, what to do in the first 48 hours of a lockout, how property rights work in a separation, what questions to ask before you ever co-sign a mortgage, leave it in the comments. I'll do my best to answer what I can. And if you know someone who's in the middle of something like this right now, share this with them. You do not have to fight this alone. I have been thinking about Roland a lot since everything settled. Not with anger. I moved past that fairly quickly, which surprised me a little. What I think about is the logic of it, the internal logic of a man who believed that because he had signed a check 4 years ago, he owned the outcome of 2 people's lives indefinitely. That is not an unusual belief. I have seen versions of it my entire career. Someone gives money, and the money becomes a leash, and after a while they forget. The leash is even there because it has been so long since anyone pulled back on it. Evan never pulled back. That was the honest truth of it. My son is a kind person, and kind people sometimes confuse keeping the peace with keeping themselves safe. Those are not the same thing. You can be gracious and still hold your ground. You can respect someone and still say no clearly. Evan had not learned to do both at once, and Roland had noticed that a long time before I did. What Roland did not account for was me. I do not say that with pride exactly. I say it because I think there is something worth naming in the idea that the people who love you are sometimes your strongest asset, and you do not have to face a hard situation with only what you yourself know. Evan knew he had rights. He did not know how to use them. I knew how to use them, and I was standing right there. That is not luck. That is what it looks like when a family actually functions, when the people in it show up with whatever they have and they put it on the table. Roland counted on Evan being alone in that moment. He counted on confusion and exhaustion and the specific shame that comes from standing on the porch of your own house with your belongings in bags while your 4-year-old watches. He manufactured that moment deliberately, and he expected it to break something in my son that would not recover fast enough to fight back. What he did not manufacture was the text he sent 2 months earlier. People who believe they hold all the power get careless with their words. They say things in writing that they would never say in a room full of witnesses because they do not expect anyone to ever make it a room full of witnesses. That text, you'll regret this, was not a threat in isolation. In context, sitting next to the below-market buyout offer that preceded it, it told a very clear story about intent. Courts care about intent. I care about intent. When someone shows you exactly what they were trying to do, you owe it to yourself to believe them and act accordingly. The thing I want anyone to take from this, not as a lesson I am handing down, but as something I genuinely learned from watching my own son sit on that bench, is that knowledge is not passive. Knowing your rights means nothing if you do not also know that you are allowed to use them, that using them is not aggression, that standing in what is legally yours is not a conflict you started. Evan had been so careful for so long not to cause trouble, that he had started to believe that being right was not enough of a reason to push back. It is. It always has been. Wren threw a penny in the fountain last Sunday and made a wish. She would not tell me what it was. She is 4, so it was probably something about a specific toil, possibly more strawberry waffles. But she looked very serious about it, and I thought, that is what you work for. Not to win against Roland, not to prove anything. You work for the kid who still believes wishes are worth making. Evan is okay. That is the whole story, really. He is okay.